So how's everybody doing? I'm going to take a minute here and talk a little bit about the progression of criminal cases, and I've had a lot of questions about that. And it's a lot of people and clients too. They come in, they hire you, they've been charged with a crime, and a good friend of mine that was a prosecutor here for many years in Clark County made the comment once that there are criminals and then there are citizens who make mistakes. So this kind of goes to the citizens who make mistakes lesson. So if you've been involved in the justice system and your first time in it, you probably are wondering, gosh, what happens? So I'm going to break this down into piece by piece by piece by piece. So they're going to be short, little informational clips about how your case would progress if you've been charged with a crime. And I'm going to be referencing Clark County, Indiana. That's the system I know. That's the system I've been a part of for 35 years. So for you to end up in court and charged with a crime, you have had to have been accused by someone or a corporation of doing something that would be illegal. You're summons to court by one or two methods. If you've been arrested, taken into custody, taken to jail, posted bond, and if you want to know about bond, I've got a little bond reform video. You might want to watch it. But if you posted your bond or you were released on your own recognizance, that means that they just let you out of jail and you didn't have to put up any money or surety. You were given a date, and that is the date to return to court. Now, if you're still in custody, they take you up in front of the judge, and they have a short period of time to do that. But that is your first most important date to know. That is your date for your initial hearing. We call that an arraignment or an initial hearing in Indiana. If you miss that date, if you fail to appear for that date, then the judge will issue a warrant for your arrest. So your case starts with either you're cited in, you're taken into custody. Upon your release, you're told when to appear in front of the judge for your initial hearing or your initial appearance, your first appearance. What is going to happen at that time is that the judge, assuming the charges have been filed, will explain to you your constitutional rights, will explain to you your right to have an attorney. He'll explain to you what indigency is if you need a public defender. He'll tell you what the possible maximum penalty would be if you were to be convicted of what you've been accused of. And he'll also tell you what the minimum penalties would be. And he will give you that information. So you're in front of the judge for the first time. And at that point, if you don't have a lawyer, he'll assess whether you're going to hire an attorney or whether you're indigent and you need a public defender. You don't have to have a lawyer, by the way, in Indiana or anywhere else. You can be your own lawyer. But at that point in time, you'll be told what your charges are, what the possible maximum penalties could be if you were convicted, what the minimum penalties would be if you were convicted. And those are the penalties, and I always say this, to your pocketbook or your freedom. The money that you can be fined and the amount of time that you can be incarcerated. Then at that point, the judge will enter a plea. Now, you can try to plead guilty at your initial hearing, but that's really a bad idea. What you need to do is you likely need to enter a plea of not guilty, and then the next phase of the case kicks in. And here in Clark County, it's called a pretrial conference. And we'll talk about a pretrial conference as the second piece of our multi-piece discussion of what happens if you've been accused of a crime, charged with a crime, and you've been summoned to court. Now, I want to remind you of this, and I'm going to remind you throughout. If you are brought up from the jail because you were arrested, and this happens many times in drunk driving cases, you get arrested, they put you in jail from the roadside, and you're there all night because there's a burn-off period, and they bring you up the next morning and you're in a jail suit, a jail uniform, when you see the judge for the first time. What I'm about to say obviously doesn't apply if that is how you first see the judge from the jail. What I'm going to say applies if you've posted bond and you've been summoned back to court. What I'm going to tell you is this. It's really very simple and clear. And I'm an older person. So in my day, this meant something different. You know, you dress for court like you're going to church. Now, your church wear over the course of time has become a little more leisurely than when I was a young person, when I was told that for the first time. But what that means is this. You show up in front of the judge, the prosecutor is going to be there. This is your first impression. The first time the judge sees you, the first time the prosecutor sees you, you want to look presentable. You want to be someone who exhibits the right amount of respect for the court, for the judge, and for the prosecutor. For this reason, you got to remember, those are the people that ultimately will be making decisions in your case as the case progresses. You want that first impression to be a good impression. I tell my clients, dress better than me if you're comfortable with a suit and tie. I always love to have a client standing next to me that's got a nicer suit on than me, and I love to have a client that comes into the courtroom if they don't have their suit and tie on because they're not comfortable in it, because that's important. Dress as the best you can, but be comfortable. Don't want you to be uncomfortable. But when you show up in court and you look like that you understand how serious it is, what has been accused of you, what you've been accused of, and you recognize the seriousness by displaying a degree of respect for the court by dressing in a respectful manner, by addressing the court in a respectful manner, and the prosecutor in a respectful manner, those are lasting impressions that can help you throughout your case. We're going to talk about the next phases and the next pieces. So, just round it up to summarize. You don't miss your court date for your initial hearing. When you get there, the judge is going to tell you what you've been charged with. He'll tell you your rights. He'll tell you the penalties. He'll tell you that you have a right to a lawyer. And he will tell you if you can't afford a lawyer, that you can have one appointed. And he will then also give you the next date. And you need to make it to that next date, or you need to make sure that when you hire a lawyer, that lawyer knows when that next date is. So, dress like you want to leave a good impression. Be respectful, know the dates, and then you finish the very first part of the case that you've been accused of a crime in. And we're going to talk next about pretrial conferences and what they mean and what happens there. So, once again, I'm Larry the Law Guy, Larry Wilder. I'm an attorney here in Clark County, Indiana. I'm not giving you legal advice. Your lawyer gives you legal advice. So if you need legal advice, go hire a lawyer. He'll give it to you. I'm just talking about the law. That's what I wanted to tell you about an initial hearing and an appearance, how your case starts in Indiana. Thank you very much. We'll be back later to talk about pretrial conferences.